Welcome to this overview of the UNIDROIT Principles on Digital Assets and Private Law, the UNIDROIT instrument that addresses the legal issues arising from the transfer and use of digital assets. The main purpose of the principles is to provide legal certainty in the market for digital assets and to harmonize private law, and in particular proprietary law, across states. They are a soft law instrument that addresses digital assets where they are the object of dispositions and acquisitions, and where interests in those assets are to be asserted against third parties. Given the lack of established practice in this field, the UNIDROIT Principles on Digital Assets and Private Law represent an original attempt at establishing an international standard on the proprietary aspects of digital assets, based on the work of experts from all representative legal families and systems.
Published in October 2023, the UNIDROIT Principles on Digital Assets and Private Law were developed through a highly inclusive process involving nearly 30 private and technology law experts, over 50 institutional observers, and a steering committee made up of 27 UNIDROIT member states and one regional economic integration organization. The result is a soft law instrument, a set of non-binding yet authoritative recommendations, accompanied by explanatory commentary. These principles are technology neutral, jurisdiction neutral, and business model neutral. Importantly, the principles are deliberate in adopting a modest approach. Rather than proposing an entirely new legal framework, the principles aim to fill gaps in the application to digital assets of existing national private law regimes. The cornerstone of the UNIDROIT Principles on Digital Assets and Private Law is Principle 3.1, which confirms that digital assets can be the subject of proprietary rights. This is a fundamental legal basis which allows digital assets to be of commercial value. Because digital assets can be the subject of proprietary rights, it follows that they can be the subject of security rights. And proprietary rights in digital assets survive insolvency.
But what exactly are proprietary rights, and how can they apply to an intangible asset? The term proprietary rights is used deliberately in a broad sense, reflecting the functional approach of the principles, which aim to accommodate all legal systems. It includes both direct proprietary interests and rights with proprietary effects, those that can be enforced against third parties. Principle 2.2 defines a digital asset as an electronic record which is capable of being subject to control. Only those electronic records that can be subject to control are covered by the instrument, and only those electronic records that can be subject to control can be the subject of proprietary rights. What is meant by control? Under the principles, control is a factual rather than a legal concept. It is the exclusive ability to prevent others from obtaining substantially all the benefit from the asset. The ability to obtain such benefit from the asset and the exclusive ability to transfer these abilities to someone else. Control, in this sense, is the functional equivalent of possession of movables. Consistent with the goal of providing legal certainty in the use of digital assets, the UNIDROIT principles include rules on innocent acquisition to protect market transactions while being respectful of national definitions of bona fide acquisitions.
The principles provide further guidance protective of legal certainty, including provisions addressing the perfection, priority, and enforcement of security rights in digital assets, rules to help determine the applicable law through a waterfall provision, and clarifications on custodial relationships, including the baseline concept that digital assets held in custody belong to the client and not to the custodian. Legislation consistent with the UNIDROIT Principles on Digital Assets and Private Law has been implemented in several jurisdictions around the globe. For example, in the United States, Article 12 of the Uniform Commercial Code addresses transactions involving certain types of digital assets referred to as controllable electronic records, with Section 12-105 defining control consistently with the UNIDROIT Principles. In March 2024, the Dubai International Financial Center enacted a digital assets law covering the legal characteristics of digital assets, including the proprietary nature of digital assets, as well as how digital assets may be controlled and transferred. The approach to control, as provided for in Article 10 of the DAL, is based on the UNIDROIT principles. The June 2023 final report on digital assets of the Law Commission of England and Wales stated that we intend that our recommendations and conclusions are broadly consistent with the recommendations of the UNIDROIT Working Group on Digital Assets. The Italian Decree Law number 25 of 17th March 2023 was drafted with the UNIDROIT Principles in mind and includes a provision on innocent acquisition as well as a reference to the concept of control.
The UNIDROIT Principles on Digital Assets and Private Law offer legislators and market participants essential guidance when it comes to the use and trade of digital assets. As a soft law instrument that is targeted in its scope, the UNIDROIT Principles support the harmonization of domestic laws, helping align national frameworks with modern digital realities. To support the instrument's global reach, the UNIDROIT Principles on Digital Assets and Private Law are expected to become available in several languages, including Spanish, Turkish, Vietnamese, Chinese, Mongolian, and Japanese. Learn more at unidroit.org.